appointed time for our meeting. I'd like to call this meeting of the Board of Appeals of the City of East Ridge, May 11th, 2020. To order. Mac, can you give an invocation? Everybody will rise for the invocation, please.
Father, we thank you for your love and your blessings. We thank you for the privilege we have of living in East Ridge, in the state of Tennessee, in the United States. We pray now for this meeting tonight, but we also pray for our country, not just our country, but the whole world because of this coronavirus. We ask you to bless us and keep us safe. Bless this meeting tonight and pray that we'll do whatever is equitable and fair to everyone involved. Forgive us of our sins. In Jesus' name we pray. Amen.
Amen. Thank you, Mac. Melissa, would you do the roll call tonight, please?
Chairman Leach.
Here.
Board Member Porter.
Here.
Board Member Sharp.
Here.
Board Member Pendley.
Here.
Board Member Spence.
Here.
Okay, we're all here. This meeting has been properly advertised
Yes, it has.
several times.
Yes.
Thank you. I do want to thank the staff, Mike and Kenny and Melissa, for all the help they give me sharing this thing. So anyway, I just want to thank them publicly for all the help they give us every time we meet. We do have minutes from a previous meeting, which is January 14th of 2019, and Mac was there. So if you'll just look at that over that, Mac, and any other board members that have an interest to look over it, was a variance request for lot size and setback on Oakdale Avenue. So Mac, I'll be entertaining a motion from you if you don't mind.
Make a motion to accept the minutes.
Do I have a second?
I'll second.
Okay, I have a motion, second. Any discussion? All in favor say aye.
Aye.
Thank you. Minutes are approved. Thanks, Melissa. Okay, a little bit of welcome to the board. We've got actually 3 new members. Mac and I, they can't get rid of us apparently, so we're still here. But
We gray-headed one though. We got a gray-headed over here.
that's good. We're all getting that way. Anyway, the composition of the board, this is for general information. The composition of our board is citizens and property owners of East Ridge. We do serve in a non-paid capacity, and we are not employed by East Ridge and receive no remuneration at all. The purpose is to hear and decide appeals from the standards of the zoning ordinance, which was adopted by the city. The basis was 1989 adoption. There are standards in the ordinance that are specified for the variances, and they mirror state law, the Tennessee Code. We're a quasi-judicial board, and I'll get into that in our continuing ed a little bit later. We can hold these public hearings, and we can make decisions based on our understanding of the facts on these cases, and actually vary from the standards that are passed in the adopted ordinance, zoning ordinance. So again, we have to monitor what the ordinance says. We have to monitor what state law allows and what the ordinance allows us to do. Our decisions are final and binding. In other words, you don't go to city council with a complaint about us. I mean, you can, but they don't have the authority to do variances. We have that authority given to us through this zoning ordinance. If you do have a grievance against our decisions, you can go to the court of competent jurisdiction downtown and take us to court. We are an administrative board, so we have some latitude, and we'll talk a little bit about this and continue yet. We have a little bit of latitude on what evidence we can allow in. We're not like a court of law. We don't have punitive authority. In other words, if we make a decision, we can't throw anybody in jail or fine them. We just can enforce, the enforcement is done by the city of East Ridge and not by this board. So what we'll do is we'll review this request. I sent some information out. I hope the board had a chance to look at it. Prior to the meeting, I sent some information out, and Melissa sent it out also recently. And it basically went through some of the thoughts about this particular case. So the new business we've got is a request from Louis Duvana, I hope that was close, for a variance from the front setback requirements in the R1 Residential District, Article 5, Section 202, height and area regulations, subsection C. And it's and I've quoted it in part in the on the agenda. It's yards with a minimum depth of 25 feet shall be provided along any public street or right-of-way for property located, and this is for property located at 1122 Bryant Road, which is public right-of-way. Part of the applicant is here, I think. Okay, we'll get to you in just a second. What we provided you in your documentation is the request, and also I asked staff if they would do something for me. When I went on Hamilton County GIS and just kind of looked at this site, and then I looked at the David Matthews survey that was done on 1/13/20. You'll notice that it's not a rectangular site. If you look at the angles, if you look at the measurements along the south property line, if you're looking at this document here, which is the map, the survey document that Dave Matthews provided, the lower property line is measured at 208 feet. The top one is 163, so you've got a deviation there on that property line. If you look at the aerial photograph, which is called GIS Gizmo 5, that's in your documentation. You'll also notice, and Melissa's pinpointed where it is on the map. You'll see that particular property, but look at all the adjacent properties. Very unusual that you would have property at angles like that coming off a right-of-way. Usually they're, and you can see it perhaps on some of the other maps here. Generally, they're not at angles. So I think, I did some map measuring for you guys before we got started, and that's included in that information I handed out, and Melissa provided. It appears that just looking at this particular lot, it appears that the setback on the south side of the building that's built certainly meets the standard of the ordinance, because they measured it off the right-of-way and they measured back to the beginning. Because of the shape of the lot, though, the north setback got tighter. It got to the 20 foot. So in general, I think the builder attempted to do it correctly. I think the angle of the lot kind of fooled them, and perhaps they can talk a little bit about that further. Does anybody have any questions about the document I sent out? Sent out to y'all about the application. I tried to figure out from a map measurement, what the difference was between the north property setback and the south property setback, and there was some difference. So the south one actually met the standard in the ordinance. So anyway, I've drawn on long enough. Are there any questions on the information? Yes, ma'am.
Is this what used to be two lots have been put together as one?
It doesn't appear to be. It's a big lot, but it doesn't appear to be.
Not according to this gizmo.
No, it shows two separate lots. Yeah.
That's correct. It actually was a church on it at one time, so it's one parcel, so it's been subdivided.
Yeah, okay. Yeah, I checked GIS, and it didn't show it to be subdivided, so thank you very much. I forgot there was, yeah, it does show, if you look under that Gizmo 5, on that Gizmo map 5, there's a church symbol indicated under the 12 there, so, yeah, interesting. Are there any other questions about that? I know that's quite a bit to throw at you right there, but, yeah. Yeah, it looks like it was 30 plus feet. I just looked at my map again. It looks like it was 30 plus feet on the south property line, setback on the building foundation, and 20 on the north side of that building. So, anyway, that's map measured. It's not 100% accurate, but it's pretty close, I think. So I think at this point, if there's no other questions about the documentation we sent out, any?
Well, what is the process, Michael? How did this happen? Number one, I don't understand how something like this could happen.
To my knowledge, what happened was when the builder dug the footings and pulled the setback requirements, he pulled it off the edge of the pavement, which he was thinking that was, the property line. And when he went back, he started digging these footings, and at that time it was at 25 foot.
So it's supposed to be taken from the middle of the thing?
Well,
Actually, the easiest way to look at right away most of the time is you look and see where utility pole is.
that's correct.
And you look on the back side of that, not on the roadside, but on the back side. Usually it varies, and this is an older area, but usually varies 6, 7, 8, 10 feet from the edge of pavement to the edge of the property. So that's a lot of times that's where the mistakes are made.
That's correct. I mean, like you said, Mr. Leach, the southwest corner of the house meets the setback requirements, but as it tapers toward, the north, roughly about 26.5 feet of the house is required for a variance. It's not within that setback requirement.
It looks to me like if they could move that house over towards the north end of the property, they could have gotten it back to where it should be.
Well, or you can move it back in the lot, but,
Yeah.
they're generally folks are just trying to lay a house out and get it built.
That's true. And if you do look at that house, it is in line with everything towards the south of McBrien, and that's kind of another thing I think they went off of, So if it's meeting those setbacks, of course ours probably would. So
Do you guys actually go out and verify footers after they pour them in?
we do. At that time, I didn't do the footing inspection on that property, so I was out of the loop on that one, so.
All right.
See, Dave, if you look at your survey drawing, that's a foundation drawing, and Dave Matthews discovered it when he was out there. So, yeah.
That was going to be my question. It was inspected after the footings were dug and poured.
That's it.
Who gave the approval on that?
One of our other building inspectors went out and looked at it.
Is he still with the city?
He's not. No, he's still with the city, but not in our department. But it's also, you gotta remember, it's also the builder as well. It's the responsibility as well to, have those surveyed.
But technically, it should have been caught at that time.
Technically, it should have been, yeah.
Okay, thank you, staff. So I guess we need to hear from the applicant, if the applicant would come forward and use that mic right there that's 6 feet away. Please give your name and your address for the record.
My name is Craig Smith. I'm representing Luis Labano. He does not speak the greatest English, and I'm a friend of his, and so I'm helping him through this process. He is, my address is 4242 Gainsthorpe Road in Hickston, Tennessee. What had happened here was Luis and his family were buying this property and building this home for themselves. And what had happened was exactly what the building official had said was he had just pulled from the road. He had actually called the city, and he doesn't do this for a living. He doesn't build houses for a living. But he called the city, said it's a 25-foot setback. All he did was to go from the road and pull back from there, and that's really it. He wanted it as close to the road as possible because he had planned on a big area in the back. That's one of the reasons he loved the lot was there's a big tree back there. He didn't want to get further back and start interrupting the roots of the tree or anything like that, and allow a big entertaining area in the back. That's really what it happened. It was a mistake on his part. He didn't realize the right of way, so when he took both corners, he thought he was well within inside of what it needed to be.
Are you the builder?
I'm a friend of his. He was building it on his own, and the application and everything is in the permit and everything is in Mr. Delano's name. I've built several houses, so I'm helping him through this process as a friend.
Has any discussion been made with him? What's going to happen if we turn this request down?
Yeah, if this request is turned down, it's and I don't know if you've been inside the property or at all, but the corner of that is in question is actually the master bathroom, shower, tub, that area. It would be very costly for him to cut that section of the house, corner it, redo the whole master bathroom area. But yeah, there's been discussion. Is there any resolution to it? No, sir. Because until we find out on this, there's really we're hoping it's a positive resolution, but we don't know of a good resolution.
Would it be more costly to physically move the whole house?
Oh yes.
Is it on slab? It's on.
It's on a slab, yes, sir.
When did the construction actually start, Craig?
To be honest with you, sir, I believe it was, and you might have when the permit was pulled on this, but I want to say it was probably somewhere in October or September, somewhere in that time period.
Pretty warm out last year, so
Okay.
I would say July, August, it seemed like it was.
Okay. Somewhere in that second half of the year.
I noticed there's not been any construction going on there lately.
Correct. We've kind of, just held on. We're, with everything that's going on, obviously all his family is concerned about what's going on with the viruses, the work that he does, and his wife, what they do. They're just kind of sitting back waiting, and then we wanted to see what was going to happen here. And we did do the sewer connection and stuff because that's, whatever happens, we got to connect that anyway.
Right.
So we did connect that, but we've kind of stopped, and our plan is if things go well, then to have it completed here within the next 30 days.
Looks like it's about 85%.
Yes, sir. It's pretty close, yes, sir.
Anybody have any other questions for Mr. Smith? Mike, did you indicate it's about a 26-foot section on that front?
Roughly about 26 and a half feet, yeah.
Which, if you'll look at your documentation, the foundation drawing from Dave Matthews, that it shows about 26-foot section there. That would be how much of the home would have to be modified. But and again, you're at an angle on the road, so it may not be that much, but it does angle back a little bit. Okay, thank you, Mr. Now, staff, if there's anybody here in opposition, how do we know that? Are they online? Do they call in? Do they text? Do they send a flare?
That I do not know.
Okay.
Was the property owners notified? People that are near that property?
They would have been notified, correct? Yeah, that's standard procedure. So my assumption is nobody's called in.
That could be them.
Ms. Smith, do you know of anybody who has discussed this with?
I know that I've talked to the.
Yes, please.
I know I've talked to the gentleman, and I'm terrible with names, forgive me, but the gentleman right across the street, the lady, the gentleman to the diagonal, if you're looking at the house would be the left. The gentleman right next door, who just bought the property through an auction, he is actually a friend of his, of Louise's, so obviously there's no issue. The gentleman that rents the property next door to them, it's a duplex, there's 2 duplexes there. That driveway is part of the reason why I think that house got slid over. If you look at that driveway, it's a circular driveway, and I think Louise just, pushed it over that way to try to provide, make sure that there's plenty of room in there. But then, so we've talked to that owner. We have not heard any appeals, negative toward that. So no, sir, I've not heard anybody. And we've done our due diligence, at least talking to the neighbors to find out if there was any.
Thank you, Mr. Smith. Appreciate that testimony. Staff, do you have any other thoughts on this? Okay, we've heard the statement by the applicant's representative. We've entertained some questions. I think we'll call the public meeting to close now at this point. We need to make a decision. We need to discuss it among ourselves if we've got other questions. So I'm open for either a motion or we can discuss after we get a motion in a second.
Because I'm new at this, I do have some questions as to, and not knowing what was allowable, I didn't go pull the deed or anything like that, but I did have a question as to whether or not if the owner came to a point where he wanted to sell this house, whether or not it reflects in the deed or in the title that a variance has been done on that property.
Yep, it would.
Okay. Because that last-
Yep, it would be attached.
It would be attached?
Yes.
Okay, all right.
It runs with the land and not the person, so
Okay.
change.
I guess my thoughts on it were that then what would be a negative to approving it, and I really couldn't come up with anything that appeared to be something that was would negatively impact as a result of approving a variance. The only thing that came up as a concern would be at such a point in time when McBride Road was widened for any reason.
And likely, if you look on that, again, on the survey drawing, there is some right-of-way.
Yeah.
They've got, it's 20 foot from center line. Just north of there is 25 foot from center line offset. But this is 20 feet, so if they were going to do that, this would not be the only property affected.
Affected. Right.
Yeah, generally, in the old days, the roads were just put in and eventually people subdivided around them. And that's why the variance on the setback could be 25 foot. That may be a newer subdivision. This one could have been an old established lot and it was only 20 foot from the center line of the right of way. You just never know. And you never know if the road is actually in the middle of the right of way or over one side. So a lot of times when you do roads, you can move them, shift them over in the right of way where you might not take houses. You can shift them over to make it more acceptable. So, anyway, good question. Any other questions, comments? No?
Steve, I'm not normally in favor of doing something like this, and I wish we'd have caught it way before we got this far along, but since the footings were dug and approved by the city of East Ridge, I think that makes it a little bit of an exception. And because of that, I make a motion that we approve.
And as part of your motion, would you also add that the lot configuration being not rectangular but angled?
I thought I just did.
Well, you did it sort of.
Thank you.
That would be the technical reason why
Yeah.
it would be, not just an administrative error. Okay. So the motion really would be to approve, subject to it, or for the reason that it was approved,
Because the
footings were approved, and
because of the angle.
configuration of the lot.
Yeah.
Okay.
I'll second.
So I have a motion second. Any other questions by board members? All in favor of the motion, say aye.
Aye.
Opposed? Okay, it passes. Now, Ms. Smith, you'll need to make sure he gets any final building permits adjusted, and the staff will have if he needs a copy for the bank, if he needs a copy of the actions of this board, you'll need to get that from staff. So Melissa will take care of it. Okay, that was our business. We do have continue ed. Now, the state law is pretty explicit. Under Title 13 is the state law that's planning, state law related, zoning, subdivision stuff. And there is a requirement under Title 13, subsection 7, 205C5, that we do 4 hours of continuing education per year. And what we've tried to do at these meetings is have a little bit of continuing ed, and that way we're going to meet the standard of the Tennessee Code. And to my knowledge, I looked it up today. It's still it is still in code. So if you'll bear with me a little bit, we're going to talk. I don't know what your schedules are, but if we can talk for a few minutes about what is a quasi-judicial decision making. Oh, yeah. Well, we need one more down.
Oh, well, yeah.
We're back.
All right, here we go.
He has to have something to doodle on. That's for the record.
Mr. Smith, I believe you can leave if you.
Yes, you're certainly, unless you just want to hear about quasi-judicial.
Okay.
It's pretty riveting.
Yeah.
Thank you very much.
Yeah.
Curiosity is, the gentleman, he doesn't speak English. Where is he from?
He's from somewhere.
Please tell them we welcome them to East Ridge.
What kind of business is he in?
His wife does cleaning. He also curb with that. He does some.
Thank you.
Thank you. Okay, so the information I've got given you handed out is a document I got from a planning magazine that I got in last year. And actually, Matt can go to sleep because he's probably heard this one before. But one of the things I do talk about when we do our briefing at the very first is we're quasi-judicial body. And if you'll look at this document, this is what they call a commissioner's kind of handbook, and there's questions and answers that go through, and authored by Adam Lovelady and David Owens. Anyway, so we're going to start on the left side of that, and it talks about certain procedures are done in order to protect due process rights of all parties involved. And what we did tonight was a public hearing, and that's part of that quasi-judicial decision-making. And one of the issues is, and I've seen it on many boards, but you do need to be fair to these individuals. You need to hear them out. Sometimes we do have folks that show up that don't like what somebody has done in their abutting property, and they get kind of fussy, don't they? And they've stormed our meetings before. But what it is this is a zoning ordinance. This is the East Ridge zoning ordinance, and it's a general law. It basically applies to all the zoning in the city of East Ridge, and it covers things like the width of parking spaces, and has a lot. But it's a general law, and a lot of times, particularly in cities like this, you have the general law doesn't apply or cannot apply to every piece of property evenly, because there are some exceptions because of the shape of the property or slope or something like that. So there's a lot of reasons why something in the zoning ordinance may not help somebody's property be developed. And, the one thing we don't want to do is have a bunch of property in a community that's not developed for that reason. Easements, or we do have property in the East Ridge that floods, and you have to the zoning ordinance covers that, and we have very little discretion with property that may lie in a flood zone. So, anyway, so the board has to come up with procedures, which we're doing. Melissa's part of that, and they advertise it for us for a public hearing. This is a very unusual one, which is going to be sent to the internet. But anyway, there are procedural due process that folks have to that we have to abide by, and folks have to enjoy. We do make decisions based on a record. Tonight we had quite a few documents. A lot of times we don't. When we had a survey document, we had GIS information, geographic information system information. We had aerial photography that was provided by staff. So we had quite a bit of information, and we could determine what the lot looks like. And I didn't know it had a church on it at one point, so it did have a building on it at one point. But then we can look at all the surrounding property, and that's another thing that you look at when you're looking at these variances. What's happening in the surrounding property? In other words, if everybody had a 20-foot setback, and because we didn't like this person up here, we insisted a 25-foot setback, is that fair and impartial to that particular applicant? You know, I've seen that happen before, not on this board. And again, it can't be if they walked up here and had a political T-shirt on that we didn't like, you know, we couldn't deny it because they had flying the wrong colors. So how is it different from other land use decisions? How is quasi-judicial decisions different? Well, you got a city council. And the city council is the one that actually passed this document. So that's a legislative activity that the city council does. We don't do legislative activities. Then there's an administrative, and that's the staff. The staff administers what's the legislative body has passed. So that's their responsibility. So that's an administrative deal. So the other one is quasi-judicial, and we do have quite a broad discretion on this board to make decisions. In other words, the staff can't say, well, yeah, we'll grant you a 20-foot setback. They're not empowered to do that, and neither is city council. But we are, because of the way the ordinance and the state law is written, we can actually do that. We're empowered to grant a variance based on the facts. And that's the quasi-judicial part of it. I always say we can't throw them in jail and we can't fine them, but we can make a determination based on facts about a variance in the ordinance. So that's a judgment for us, and it's one of those that I take very seriously. We really need to look at the evidence that's given to us. Sometimes we have to drag it out of applicants. They're not quite sure or whatever. So sometimes we have to ask a lot of questions. The staff has to ask questions. And most of the time we can drag the right information out. So in fact, we're like a court, almost, administrative court, where we accept the facts, we look at the facts. It's interesting because in a judicial proceedings, there are very standard, there's rules of evidence. We have a lot more discretion because we can ask people for information, and we can actually take hearsay evidence if we need to do that, which is not like a regular court. So anyway, it's kind of a strange beast that we represent. You know, we're not making the rules, we're not writing the rules in the zoning ordinance, we're not enforcing the rules. That's the staff, but we can interpret the intent sometimes of the ordinance. We can make decisions based on the facts we're presenting, and that's sort of where this body ends up. So one of the things I do caution us about, we'll talk about maybe next time, is something called ex parte discussions. Now we're all in a small town, and we have neighbors and friends. Sometimes the neighbors and friends have a zoning issue, and they want to talk to you about it in church or at the grocery store. And ex parte is when you talk about and really say, yeah, I can support that. somebody calls you up and says you found out that you're on the board of zoning appeals, they call you up and say, I want you to commit to yes or no, or maybe we do business with them, and they say, you know, I'll give you this tire at a discount, but I really, you know, all those discussions that are held outside this body, that's not a good thing. It's called ex parte, and you don't want to be in that situation where you made a promise. I've seen it done on boards before where somebody said, well, I talked to Joe on the phone and he said he'd vote for it. And so people will say the darndest things when you get up to a meeting sometimes. So, you know, don't, if somebody approaches you and know that you're on this board, just never commit to, you know, just listen to them and say, well, yeah, okay, we'll take that under advisement, but don't commit to a decision outside this location, okay? That's just a warning, because small towns is like that. I mean, I've had them call me, I've had them threaten me, but that's a different situation.
That was one of the reasons why I did not do any research on my own about pulling a deed or something. I did not know if that was an appropriate
No, you
behavior.
can do. In fact, I always want people to drive by the cases. You need to drive by.
Oh, yeah, I did that.
And if you stop, though, sometimes when people ask you questions, you know, what are you doing, how are you doing? So I always try to be very,
Especially now.
yeah, what are you doing? Where's your mask? I try to be very quickly. If I'm going to visit site, I try to go there and visit very quickly, and just kind of. Sometimes in fact, this particular site I went by about 3 or 4 different times in different directions, just to kind of get a lay of the land. But again, just be careful about that. You know, it's everybody wants to be heard, and that's why we have a public hearing. And that's the time to be heard. It's not at the grocery store or at church. Yes.
This hasn't happened to me many times, but I've been on this board for several years, I don't know how long. But it's happened maybe 3 times, and it's usually at church. And what my answer is, I'm sorry, I cannot discuss it outside of the courtroom.
That's great advice.
We'll-
Yeah, that's great advice, and really, people call you up and talk to you about it. It's kind of nice now that there's no phone books. They can't look you up anymore. We had one guy that apparently looked me up based on a negative decision we'd made. And before I got home, my wife met me outside and said, such and such had called. And so he was not happy. So no more phone books, no more calls. But anyway, just be careful of that. Ex parte communications are not good. But again, in a small town, sometimes it's hard to.
We had one guy when we voted against what he was done, he told us, I'm not going to vote for any of y'all again. I said, great.
All right.
When is the election?
Right. Anyway, again, I'd like to thank everybody for their willingness to serve back, and staff. Really appreciate y'all. Appreciate your willingness to give a little time to the community. It's a great community, and it deserves a little bit of our time. So anyway,
Steve?
Yes, sir.
Let me ask the new members a question.
Okay.
What is your business background? What's
I
your-
work for the state of Tennessee. I'm an elevator inspector for the state.
Okay.
yes, it's ups and downs.
Somebody?
And even me.
Dan?
I worked for 5 years for a civil engineering firm, and we dealt with commercial clients, and so I often had to do research on zoning restrictions, zoning applications, site plans, elevations, so I have some background in
I'm retired.
Yeah.
I worked 33 years with the Assessor of Properties Office, and my last position, I was a commercial industrial supervisor. So I'm pretty familiar with all this stuff.
How long were you there?
33 years.
33 years. Do you remember Mr. Illis, Andrew Illis?
No.
I do. Let's close the meeting, and again, thanks for your service to this community, and looking forward to seeing you soon.
Thank you.
Meeting's adjourned.